Crypto Twitter is awash with the rumor of SEC Chairman Gary Gensler resigning from the regulatory agency. Pro-XRP attorney John Deaton commented on the rumors, saying a Gensler resignation was possible. Outspoken pro-Ripple lawyer John Deaton has voiced confidence about the SEC's EVs. Ripple action, saying that Judge Torres would fully examine the central issue of whether XRP is a security in her future summary ruling. On Monday, Deaton said unequivocally, XRP is not a security. He then drew analogies between XRP and other assets like as orange orchards, whiskey, condominiums, and even Bitcoin. BCC, Deaton's thesis focused on the fact that, although being advertised and sold as investment contracts, these assets' basic qualities remained unchanged. Each was once sold as an investment contract, SECUV, shavers, but that particular sale didn't transform BCC into anything other than what it is, a digital commodity, he said. Furthermore, contrary to popular assumption, Deaton said that Judge Torres would not be afraid to confront the problem of XRP secondary sales. I believe Judge Torres must address the underlying asset and secondary market sales. Could she dodge the concerns and yet make a ruling? Of course she could. However, ignoring the SEC's premise and failing to address these difficulties would be a bigger act of judicial activism, according to him. To bolster his point, Deaton cited a similar case heard by Judge Castile in 2020 regarding the Telegram messaging software. This legal battle started when the SEC intervened and delayed Telegram's planned distribution of Gramcoin's planned distribution of Gramcoin. However, Judge Castile ruled in favor of the SEC, ordering Telegram to reimburse investors $1.02 billion from its failed initial coin offering, ICO, for the Telegram Open Network. It is critical to note that the SEC's assumption was that Ripple participated in ongoing activity resembling an ISO, seeing each sale of XRP as part of a larger strategy involving security. However, Deaton highlighted that the situation with XRP different from the Telegram case since the latter constituted an ISO with written contracts. Deaton further claimed that XRP, which is powered by the XRP technology, has been operational and publicly traded for more than 7 years. Notably, even SEC employees were able to acquire XRP until 2019, which was not the case with the Gram cryptocurrency. The issue of XRP secondary market transactions has been a key point in the litigation struggle between the SEC and Ripple. While the SEC accused Ripple of marketing XRP as an unregistered securities, it failed to differentiate between Ripple's direct sales and subsequent secondary market trading, resulting to misunderstanding. Deaton recently said that Judge Torres may consider this issue based on a prior examination in the SEC versus Elbry action, since it puts additional light on the matter. However, although there is no assurance, Judge Torres' summary judgment opinion might shed light on XRP's security classification, possibly having a big influence on the crypto sector. Judge Phyllis J. Hamilton of the U.S. District Court for the Northern District of California has granted class certification in the class. Action Lawsuit Zakhanov EC. Ripple Labs in. At a critical point for XRP investors, the main complaint revolves upon Ripple's failure to comply with federal and state rules by failing to register its digital asset, XRP, as a security. This decision allows a large number of XRP purchasers to file securities lawsuits against Ripple, its subsidiary XRP-EE, Ezio Bradley Garlinghouse, the last court date in the XRP investor class. Action case against Ripple was 2 months ago. Bradley Sostek, the main plaintiff, filed a request to assemble a class of global XRP owners who purchased, still hold, or have sold XRP at a loss. Despite Ripple's international presence, this order affirms the right of us investors to take legal remedies. Defense attorneys successfully argued that the litigation should be limited to us investors. Judge Hamilton acknowledged the changing legal situation around cryptocurrency in this complicated legal sector. She emphasized the difficulties that different countries face when classifying digital assets, emphasizing the importance of allowing individual jurisdictions to enforce their cryptocurrency regulation. She added, "This ruling marks a significant step forward for the lead plaintiff and his legal team who allege a loss of $118,100 after selling XRP in 2018 due to Ripple's misleading claims about the token's security status. This opens the door for other XRP investors to join class action and seek compensation for their alleged losses. The defense attorneys for Ripple and Garlinghouse contended that class members had differing opinions on XRP security status, which they believed would lead to strife within the class. Judge Hamilton, on the other hand, dismissed this argument, indicating that any objections could be resolved through the regular opt-out procedure. Sussman Godfrey's Nick Spear expressed pleased with the court's ruling as the case moves forward. A Ripple spokeswoman emphasized the court's rejection of a worldwide class and the significance of allowing other countries to regulate cryptocurrencies independently. The court's willingness to wait for the outcome of the SEC Ripple case before proceeding was also noted by the spokeswoman.
The SEC Ripple Labs court fight is one of the most high-profile cases, and as the industry awaits the decision, a lawyer anticipated the likely release date based on Judge Annalisa Torres' summary judgment ruling trend. Pro-Ripple lawyer Fred Rispoli said that the court's verdict in the continuing legal dispute between the Securities and Exchange Commission and the blockchain and software startup Ripple Labs might be released in August. The lawyer highlighted that 60 of the federal judge's rulings came between 146 and 330 days, with the judgment announced in an average time of 249 days. Using statistics related to the motion summary judgment of the United States District Court for the Southern District of New York Judge Annalisa Torres, who is handling the case. Based on these figures, the decision should have been issued on May 21, the 249th day after the original application for summary judgment was filed on September 17, 2022. However, it is no longer valid since that month has passed with no news from the court. Rispoli also hinted that the 330-day rule might be implemented in the SEC Ripple Labs case, and if that happens, the court's decision is expected on August 10 of this year. 60 of rulings are issued between 146 and 330 days, which is 249 days from September 17, 2022 to May 2023, and 330 days from September 17, 2020 to August 10, 2020, and 330 days from September 17, 2023. I may be getting the best birthday present of my entire life, the lawyer remarked, adding, peas, or the worst birthday present ever, either of those two. Rispoli's prognosis is a tad early in comparison to another pro-Ripple lawyer and crypto law creator John Deaton, who earlier projected using statistics that Judge Torres' decision may be issued on September 6. Deaton utilized Judge Torres' 6-month timescale finding on the Daubert motion in the Ripple Labs litigation on March 6, arriving at the September 6 date. She decided a case in which her summary judgment decision came 6 months after her Daubert decision. So if her Daubert ruling was made on March 6, it would be September 6, 6 months later. Deaton said in a live video. Ripple Labs CEO Brad Garlinghouse has previously said that the continuing legal struggle is coming to a close and that the verdict might be issued in weeks.